Let's talk.
Giles Brown.
Rough Justice is a gripping insight into Britain's criminal courts from the Sunday Times bestseller of Unlawful Killings. 4 gripping stories from the Old Bailey that force us to consider, what is justice? Do our legal courts dispense it? Has our judicial process improved for victims, the accused and society? And what more can be done? Delighted to say that for a second time, I can welcome onto the show Her Honour Wendy Joseph KC of Rough Justice. Your Honour, good morning to you.
Good morning to you.
I was going to say it's been a while since I said that, but let's not go there. Good to have you back on the show as well. The first book was rapturously received. So what are we looking at in Rough Justice?
So I wanted to write a book about those who find it hard to access justice in our courts. And when I started to look at the people who are particularly vulnerable, have a particularly difficult time making the system work for them, again and again, I found that it was women, girls, those who are mentally ill, the fragile amongst us. And so I thought it would be interesting to concentrate on those and what we can do to help them.
I suppose one of the things when we look at this is if you're involved in the workings of a criminal trial or any sort of trial, then you become accustomed to it as you would do in any job. But one of the problems is when you are brought up in front of a judge, a magistrate, whatever it is for most of us, thankfully, this is an entirely different world, an alien world, and it can be very, very, what we may think of as normal every day, from somebody from outside that sphere, can seem incredibly intimidating and frightening.
Yeah, I mean, I think that's absolutely right. And it was particularly so at the Old Bailey, because we do try there, the most serious of cases. So almost everything I did there for a decade had either a dead body or a nearly dead body in it. And the result of that is that the people who are using the courts are really at a critically low point in their lives, whether they are the victims or the bereaved or the witnesses or the defendants. They are people who are really going through the mill. And the rest of us, the jury who are involved in making the decisions, the barristers and the judge, we are really on the periphery of it all. As to the events themselves, but we're pretty central as to the trial. And it's really for us to try and make the system work.
So how do you think we should go about making the system a little less, well, A, make it work, and B, make it a little less intimidating? Because, some listeners will be throwing their hands in the air going, oh, for goodness sake, this is wokery at its worst. And, we have to. This is the way it has always operated. So this is the way that it should be done, especially when you're talking for cases, as you say, that either involve a nearly dead body or a dead body, because it is the Old Bailey.
Well, let me take an example that could actually crop up at any court, because I wouldn't want people to think, oh, well, this only applies to one court. So if you take an example of, the first story in my book, a 12-year-old little girl who has been raped by an adult neighbor. In the old days, what would have happened is if she'd made a complaint, at what stage she might have found the courage to make the complaint, she would have had to have described in detail what had happened. It would have been written down. Months and months later, perhaps years later, she would have had to have gone to court and been questioned about it. She would have had to have stood up in a courtroom in front of a lot of people, with the defendant looking at her, with a room full of strangers looking at her, describing in detail what had happened. She then would have had to have stood there and been challenged about it by the defense barrister. probably called a liar, or at the very least a fantasist, or at the very least mistaken. And then she would have to have known that people would be judging whether they could rely upon her word or not. What we have got these days is a very different system. And I would like to think it gives a fairer chance to all parties involved. So first of all, her account would now be pre-recorded at the very early stages when she made the complaint. It would be on video so that everyone could see, particularly the jury, how she explained what had happened. Then we also have a system now where she can have her cross-examination pre-recorded before the trial itself. Even if that isn't done, we have for a long time now allowed her to have a screen in front of her when she gives evidence if she has to go into the courtroom. So she doesn't have to see a lot of strangers, and the only people who can see her are the jury, the judge, and the barristers. If we have to have her in the court and she's not up to going into the docket, into the witness box itself, we can allow her to use a remote witness room and be joined to the courtroom by a video link. We now have a system by which the judges can control the sort of questions that are asked of her so that they are deep and check the truth of matters, but are not intimidating and don't use language beyond the capacity of a 12-year-old. So forgive me for going on, Giles,
No.
but that paints the picture of all the things we have tried to do, not out of wokeness, but to create a level playing field so that all parties accessing the courtroom can have a fair crack of the whip.
During my younger days, when I was working as a junior reporter, you do an awful lot of courts, as you will do, and namely they're not normally sort of boring, mundane things, but you sit in there as a cub reporter. And one of the things that struck me, and I talked about the theatre of it, but the thing is that certain people can react better to the situation they find themselves in. People may argue that a court is the right and proper place to try this, and out in the open, live as it were, in front of a jury of one's peers, etc. But there are I've seen certain defendants who have absolutely clammed up and be starstruck, and they've got, if you like, stage fright before they go on. And if you take away the whole, again, and I'm not using this in a derogatory, the whole theatre of performance that is a major trial, then they may be able to because they may be able to tell their truth, because people will revert to type, or they may go into their shells. And in a high stakes, if you like, criminal case, that can be the worst thing that a defendant can do.
Yeah, I mean, that's also true. But I think it's really for the judge to manage the case, to ensure that, as I was just saying, that everybody, and that really does include defendants, everybody has a fair chance. And so although the courtroom is quite formal, and the clothing that we wear is quite formal, the wigs and the gowns, by the time a defendant gets to the point of giving evidence, which is towards the end of a case, it really will have been for the judge to set the tone, to make sure that everybody feels relaxed. It is important that the formalities are observed, but not at the cost of reaching the truth, because that's what we're there for. And, everyone thinks judges are good at the law. Well, you have to know the law, or you have to know where to look it up and how to apply it. But it really is, the point about running a courtroom really is about making sure that justice is done at the end of the day.
The book is called Rough Justice, and it said, "Do we have justice for all?" Are we? Do you think that some people will come in with a prejudice against certain defendants or certain people because with the sketchiest of outlines of the defendant's life, they think they pretty much have the idea of how this person's life is and their motives? Is this what we're looking for rough justice?
If you think about a jury of 12 people who have been pulled at random off the electoral register, they could be any one of us, including judges. I've done jury service. So really anyone at all. And you're going to get, or you should get, such a mixture on your jury that you can be sure of a number of things. One of which is that people will bring their personal prejudices into the courtroom, into the jury room. But the other thing is they are going to hear the views of 11 other people, and they are really going to have to talk through the issues. And my experience of the system is that I think jurors learn a lot about themselves and each other in the course of actually doing justice on behalf of all of us. And I think that we can trust our juries to reach fair verdicts at the end of the day. I've been doing the job for 50 years, nearly 50 years, and I can think of but a handful of cases, maybe 2 or 3, where I think that a jury deliberately and knowingly brought in a wrong verdict. It's not great they ever did it at all, but it's not a bad percentage.
With rough justice, are we looking? You've taken it's 4 cases, isn't it? We're looking at in detail, and you're drawing sort of comparisons. We're looking at some miscarriages of justice. Are you trying to sort of highlight these so that hopefully we do not repeat these same patterns again?
I think it would be quite presumptuous of me if I thought I could achieve anything like that. But the idea was that if we raise issues and we think about them and we talk about them, there's a chance that we can make things better. And if we don't acknowledge them and if we don't think about them, then they're just going to go on in the same way. And so what I've done is just take 4 scenarios, the sort of things that I have seen happen over and over again during the decades that I've been working in the courts. Because, I've been a barrister since 1975 and a judge since 2007. And I've just explored the different issues that arise in the hope that they will resonate with people. I sort of hope they're good stories too, because otherwise people won't read them. But the idea is that they should actually make us stop and think about whether we've got things right. And Giles, one of the things I did, really quite by chance, was I went back into the archives just to see if I could find in the Old Bailey archives similar cases. So with the case of the little 12-year-old girl, I typed in the words rape and child. And because I'd called my protagonist Susan, on a whim, I typed in the name Susan. Up came from 1735 a case in so many ways similar, where a little girl was making a complaint against a neighbor, and the questions of cross-examination that had been recorded by the scribe in 1735 were exactly the questions I hear asked in a courtroom today. If it really happened, Susan, why didn't you tell your mum as soon as you got home? If it really happened, Susan, why did you ever go back and talk to him again? So, things don't change. People don't change. But we can change the system.
Talking of the system, in the decades that you have been practicing the law and from barrister to judge, how have you seen the system changed? Because obviously in 1975, 1976, there were many women barristers. I suppose again, and those who think we've all gone completely, again, I use that W word again, woke. We now have more diversity. We now have more women working in law, and this obviously has to be a good thing.
So when I came to the bar in 1975, there were a very small handful of very successful women and a few others who were joining the bar like me in the hope we would get there. We weren't badly treated, but we were treated like toys. We weren't taken seriously. Now, I think there are just over half of those admitted to the bar are women, and they do very well. Now, Giles, that isn't to say there aren't problems, because, in their late 30s, they hemorrhage away from the bar because they want to have children, and it's hard to come back. But when I went to the Old Bailey as a judge in 2012, there were 16 full-time judges there, 15 men and me. When I left, exactly 10 years later, the percentage of men and women on the bench at the Old Bailey was 50-50. And now there happens to be one more woman than man. It's not like that in every court, but I think that's a bit of a success story, I like to think.
And do you think that women would bring more empathy to the law? Because the law, although people who are outside it may think it is all a huge amount of frightening text law books to read, but actually the law is a living, breathing thing that needs experience in the world to operate. It is not a sterile thing. And women bring empathy and understanding in a way that, with the greatest of respect, perhaps quite a few, I was going to say QCs, but KCs, who are predominantly male, haven't had that experience.
That's such an interesting question. Could I draw the distinction between sympathy and empathy?
Absolutely.
Sympathy's got absolutely no place in a judge's mind. It's no good saying, I feel terribly sorry for this side or that side. But empathy, understanding how everybody in the courtroom is functioning in order to be able to give them the chance to give of their best, is absolutely critical. It may be that women have, I won't say better at it, they may have had more experience at it than many men have. But it's actually a key skill for every judge to develop, certainly in the criminal courts. I think civil courts can be different, but in the criminal courts, for all the reasons we've been talking about, it really is a key ability.
This just struck me, but what goes through a judge's mind when there is a high profile at the Old Bailey? When you drive in and you look out and you see the camera crews and you see the people, and there, we may have evolved as a society, but there is still that whole sort of public. We don't go back to sort of public capital punishment, but it draws a crowd. There are people outside. It is a quote unquote an occasion, and then you go into your chambers, into your office or whatever, and you prepare. Do you have that? Almost like going onto a sporting field. Do you have that moment of deep breath and here we go sort of moment?
I'd love to say every single case is exactly identical and the pressures are the same in every single case. But you're right, it's not true. There are cases where there is an additional pressure. I don't think it's the adrenaline rush of going onto the field at Wembley, or walking out onto Centre Court at Wimbledon. I don't think it's like that, because it isn't really about the judge. But where you know that there's a large public interest, particularly if they are difficult issues where the public may not necessarily fully appreciate the way in which the court is working and the issues that the court is having to grapple with, there is this additional need that every word that you say is going to be pored over, taken apart. Anything that you say wrong will be exposed. anything that you say that is capable of being misunderstood might be misunderstood. And so there are additional pressures. But hey, you take on the job, that's what you take on.
What are you hoping that people, because you've done this before, as I said, your previous book was very well received, to put it mildly. What are you hoping that people will take from Rough Justice?
I hope most of all that anyone who reads it finds it interesting, gets to the end because they're actually wanting to understand what's written there. And I hope very much that they will enjoy reading it because, it's not a textbook. It so isn't a textbook. It's a book of stories, really. So I'm hoping that is how they are feeling. But at the end of it all, I really hope that people will go away and have a little think about whether we are doing the best we can, and if we're not, how we make it better.
And I have to ask you this final question, because it's something you said earlier in the interview. It said that you too have done jury service. And I'm just wondering what the reaction of the judge was when he walked in and glanced, looked at the defendant, looked at the barrister in front of him, and then he looked to his left and saw you sitting in the jury. Was it a sort of double take? Did he think, oh blimey, I better up my game, or she, of course, did they think, oh my goodness, I better up my game because Wendy Joseph is in the jury?
Well, he so studiously didn't look at me that I knew for sure he'd been forewarned that I was there. But, Giles, I've actually had at the Old Bailey, when I've been sitting as a judge, I had another judge on my jury. And actually, it was a very difficult case, a case of diminished responsibility, which is the issues in the law are difficult. And I actually was glad that there was someone there that I knew would understand the law. It was really nice to feel that there was someone who was an insider looking at the facts of the case. You very rarely get that happening, and it's really the judge's responsibility to make sure everybody on the jury gets it. But I felt it was no bad thing to have him there.
The book is called Rough Justice by Her Honour Wendy Joseph, KC. Wendy, if people want to find you online, do you have a website? Do you dip your toe in the waters of social media?
I don't, Giles, and I sort of I know I'm supposed to, but the thing is, as barristers and judges, as judges in particular, we were not allowed to do it. And I'm pretty long in the tooth to be learning.
You'll be able to download the book, or you'll be able to order the book from our own virtual bookstore. The book is called Rough Justice. It's by Her Honour Wendy Joseph, KC. Wendy, once again, it's been an absolute pleasure to speak to you.
Thank you, Giles. Thank you.